Assalamualaikum warahmatullahi taala wabarakatuh. Okay, in this video, I'm going to talk about the auditor's legal liability. This is a second series to this topic, and this topic is actually for the degree of accountancy program at UiTM. Okay, in this video, I'm going to cover the governing laws relating to the auditor's legal liability. I'm going to continue with types of liability, and then I'm going to go through the cases that relates to auditors legal liability. The subtopic related to legal environment and rights in litigation, limiting liability of the auditor, the expectation gap, and key terms in legal environment have been discussed in the first series to this topic. We are going to look at the three laws that govern the auditor's liability. The first one is the statutory law, second contract law, and the third one is the common law. Statutory law is actually related to the laws enacted by the government. Contract is usually the contractual agreement between auditor and the client. And the common law is the law which is developed through the court decision. There are several liabilities that the auditor might face. The first one is the civil liability under the statute, where the auditor could be committing ordinary or gross negligence or also committing fraud. Auditor also can face criminal liability under statutes. This might be a situation that auditor violates certain statute. For example, like the auditor violate the AMLA 2001 Act. The auditor can also face liability to client for breach of contract agreement. Auditor can also be liable to client under common law, which the auditor has breached the contract or is negligent, which can be ordinary or gross negligence and fraud. And also auditor is liable to third party due to negligence, gross negligence and fraud. When the auditor breach of contract, it means that the auditor failed to complete his job as stated in the contract or in the engagement letter. Okay, the contract can be expressed or can be impliedly stated. Okay, express it means that these are actually written in the engagement letter. Implied it means that these are not stated. Implied term, it means that these are not stated because it is too obvious to express. For example, like duty of care. It is understandable that when the auditor is engaged to perform the audit work, the auditor has to perform the audit work with due care. And furthermore, the MIA bylaw states that the auditor has to carry out the audit work with due care. Auditor has to comply with this statutory law, which is laws enacted by the government of Malaysia. The purpose of this statutory law is actually to safeguard the interests of the shareholders, the owners, the depositors, the investors, as well as the public. Non-compliance to the statutory law would result auditor to face the civil liability or the criminal liability. These are the statutory laws that the auditor has to comply. The first is Companies Act 2016. Everybody knows about this act. And then we have the Securities Industry Act 1983, which relates to the trading of the security that require auditor to observe this. And if there is a breach, then the auditor would be liable. And then after that, the Securities Commission Malaysia, this relates to the prospectus. If, let's say, the auditor discovered that the prospectus did not comply with any accounting standard, then the auditor would be liable under this act. The next act that the auditor has to observe is the Amlat FA 2001, where the auditor has to report about the suspicious transaction and the cash transaction of the client if the client has transacted for an amount exceeding 25,000. Also, the auditor has to observe securities industry, the Central Depositories Act 1991, as well as the Capital Market and Services Amendment Act 2015. So these are some of the statutory laws that the auditor has to observe. Common law. Before we go into this, let's look at the contract law. Contract law, as I said, this is actually the agreement between the client and the auditor. And the terms of agreement are stated in the engagement letter. So when the auditor failed to meet this agreement, then the auditor is said to be in breach of the contract law and will be liable under the contract law. Okay, what about the common law? Common law is actually the law that has been developed by the previous judges when deciding a case. And the opinions or the principle used by the judge to argue about the case will become the principle which might be used by later judges when deciding a similar case. The auditor under common law might be liable to client and to third party for negligence, gross negligence, and fraud. However, it shall be noted that although common law is used by the later judge, but sometimes the later judges might not use the same principle or opinion given by the previous judges. So the cases where the future judges decided which are similar to the previous cases doesn't mean that the outcome will be the same. And this can be due to who sit in the court, which judge sit in the court, and also it depends on the geographical location where the case is decided. Let's look at the common law, the liability faced by auditor. Okay, in this common law, usually the auditor is the defendant and the third party is the plaintiff. For a successful action by third party against the auditor, the third party has to prove four conditions. The first one is actually to show that the auditor owed a duty of care to plaintiff, and then also the plaintiff must show that the auditor failed to carry out that duty of care. The third condition is the plaintiff has to show there is a causal relationship between the auditor's negligence and the damage suffered by the plaintiff. And fourthly, the plaintiff has to show that he suffered actual damage due to the auditor's negligence. Let's look at the auditor's liability under common law. The case that we are going to refer to is the US case that happened in 1931, the case of the Ultrames versus Dushi et al. Okay, in this case, the auditor had actually issued certificate of audit as requested by the client. And also the auditor had actually certified that the capital and the surplus of the business to be in excess of 1 million US dollar. The auditor was aware that the certificate of the audit was going to be used by the client in order to obtain financial assistance, as the client was actually facing financial problems. The plaintiff, subsequent to that, had actually relied on the certificate and provided loans to the client. Not long after that, the client's business collapsed, and now the case was brought to the court. In deciding the case, the judge had actually used the first condition, that is to determine whether the auditor actually owed duty of care towards the plaintiff. And here, based on the judge decision, the judge argued that the auditor did not owe duty of care to the plaintiff, but owed the duty of care towards the employer or the client. Hence, and the judge made a decision in favor of the auditor, the defendant, and go against the plaintiff. And the judge had also dismissed the plaintiff arguments that claim auditor was negligent and had actually misrepresented the information in the certificate of audit. The second case that we are going to look at in relation to the auditor's legal liability under common law is the UK case which occurred in 1951. This is the Chandler versus Crane, Christmas and Co. Okay, in this case, the auditor had audited the accounts of the client, and the auditor acknowledged that he was negligent in auditing the accounts. The auditor was also aware that the audited accounts would be used by the plaintiff for investment decision. Based on the set of the audited accounts, the plaintiff made decision to invest in the client's business. And not long after that, the company's business became insolvent. The plaintiff brought the case to the court and sued the auditor based on the ground of negligence. And in the Court of Justice, the judge held that the auditor owed no duty of care towards the plaintiff, that is Mr. Chandler, because simply that there was no contractual agreement between them. The plaintiff wasn't happy and had actually taken a step further by taking the case to the Court of Appeal. And again, in the Court of Appeal, he was not successful because the judge decided against him, the plaintiff, and in favor of the defendant, the auditor. Also based on the grounds that the auditor owed no duty of care towards the plaintiff, simply because there was no contractual agreement. So you can see that under these two cases, the Chandler case and the Ultraman's case, the judges were more favor to decide against the plaintiff when there were agreement between the plaintiff and the auditor. However, in the absence of the contractual agreement, the judge would be in favor of the auditor. However, the decision made by the judge that said in this case attract the attention of Lord Denning, who observed the decision made by the Court of Appeal. Lord Denning was actually the Court of Appeal judge, and according to him, he argued that the auditor should be made liable because the auditor had actually committed negligence. And this dissenting argument had actually attracted in later cases that we are going to look at later. The third case that we are going to look at in relation to the auditor's liability under common law is the case of the Hadley Bryan versus Heller and Partner. This is also the UK case that happened in 1963. Okay, this case is actually very interesting because it had actually eroded the privity of contract doctrine in determining the duty of care of auditor towards the plaintiff. So it means that the privity of doctrine on the contractual agreement is no longer used in deciding the case as a result from the decision from this Hadley-Burn case. Right. Also, from this Hadley-Bryan versus Heller and partner case, the duty of care now can be implied if the two parties, the first party and the second party, are sufficiently close and proximate. For example, like we have here that there is a party seeking advice or asking for information from the second party, and relying that the second party will use his skill and competency in providing the information, and also the second party knew that the first party would rely on the information given by him. Then if the second party was negligent, duty of care would be implied here. The duty of care would be implied where the second party is said to have duty of care towards the first party. Let's look at the fact of the case. In this case, it was not related to auditor but related to the Mission Bank, Heller and partner. Heller and partner had actually provided the credit reference to Hadley-Burn about the financial status of a potential customer of Heller by the name of Easy Power. Based on the credit reference, Hadley-Burn continue providing the advertising service to Easy Power, which subsequently went into liquidation. Hadley-Burn then had taken the case to the court and claimed that Heller had actually committed negligence when preparing the credit reference. The case was brought to the court at lower court. The plaintiff failed in his litigation against Heller, and Hadley was not satisfied and brought the case to Court of Appeal. Again, at the Court of Appeal, Hadley failed, and subsequently he brought the case to the House of Lords, which is the highest court in England. Okay, in this court, the judgment went in favor of Hadley-Burn, and it was not in favor of Heller. The reason was that, according to the judge, they argued that Heller owed duty of care towards the plaintiff, even though that there was no contractual agreement between Heller and Hadley-Burn. And the grounds for the decision was that the duty of care is actually implied, where Heller should impliedly providing the credit reference with duty of care to Hadley-Bryan. However, Heller actually escaped liability here, or the defendant escaped liability, because simply that in providing the credit reference, Heller had actually included a disclaimer clause where they were not responsible for whatever information provided in the credit reference related to Hadley-Burn. In making decision in favor of Hadley-Burn, the judge had actually come up with 3 reasons. The first is that, according to the judge, the bank, Heller, was aware the credit reference was going to be used for a particular purpose. Also, a known party, that is Hadley-Burn here, was intended to rely on the credit reference provided by Heller. And also, there's a relationship between the conduct of Heller, which can be linked to the party or the Hadley-Burn who relied on the financial statements, on the credit reference. Okay, this is actually the example of disclaimer. So as a result of having this disclaimer clause in the credit reference, that's why Heller escaped liability towards Hadley Burn. The decision made in Hadley Burn's case had actually extended the auditor's liability under the common law. So here we can see that the auditor is liable to the plaintiff when there was duty of care, but this duty of care now is going to be impliedly referred to when there is a close relationship between the auditor and the third party. And also, as a result of the Hadley Burns case, and the court now had actually used two tests to determine how close the auditor in relation to the third party. The first one is the test of foreseeability, and the second one is the test of reasonable foresight in the Jeb Fastener's case. This test of foreseeability and the test of reasonable foresight had actually impacted the auditors, where as long as the auditor knew that there will be third party that who would rely on the audited accounts prepared by auditor to make decision, the court would be more ready to establish the duty of care of auditor towards that third party. Let's look at this case and the case of the Jeb Fastener and Max Bloom. Okay, in this case, the implication towards auditor is that it had actually broadened the auditor's duty of care. If let's say the auditor had actually known any party would rely on his audited financial statement, then auditor would be said to have duty of care towards that particular party. Now let's look at the Jeb Fastener case, the fact of the case. In this case, Max Bloom was the auditor of BG. BG was actually going to be taken by the Jeb Fastener, and Mark Bloom had actually prepared the audited financial statement carelessly by not verifying the inventory figure. And the Jeb Fastener, who is actually interested in acquiring the entire shares of the BG, said to have relied on the audited financial statement prepared by Max Bloom, or the auditor here, and finally acquired the entire shares of DBG, and later they discovered that BG had actually suffered large loss. Now, the Jeb Fastener claimed that Max Bloom had actually been careless and had been negligent in auditing the BG's financial statement, and Jeb had actually taken the case to the court. In this case, the judge made the decision in favor of the plaintiff, arguing that the auditor would have reasonably foreseen that the audited financial statement would be used by BG, which at that time faced serious financial problems, and would use that to get finance from the outside. And also the auditor should have reasonably foreseen that whoever is going to acquire BG would also rely on the audited financial statements. So these are the arguments put forward by the judge in making a decision against the auditor. So this actually affects the audit profession when the auditor is actually going to be liable to virtually almost anybody who relied on their opinion, and this means that the auditor would face greater liability. It is interesting to note that even the judge made the decision in favor of plaintiff. However, the final decision was that the judge made the decision in favor of auditor. This is because the judge argued that even though that Jeb Fastener would have known that the accounts were misrepresented by the auditor, Jeb Fastener would still go ahead with the acquisition of the entire shares of BG. And the reason was that for them to acquire the service of the former directors of BG. From the cases that I had discussed, we can see that before the judge made the decision in favor of plaintiff or auditor, the judge would first of all look at the relationship between the two of them. And from these cases, four relationships can be identified. The first one is the privity relationship, which defines whether there is a contractual arrangement or agreement or not between the auditor and plaintiff. The second relationship is the primary beneficiary relationship. The third is the foreseen party relationship, that is whether known or reasonably expected to be known and rely on the auditor's work in making decision. And lastly, the relationship that defined as foreseeable party relationship. Okay, this is about not known to auditor but reasonably expected by auditor that certain party will rely on the financial statements. Let's look at the Caparo versus Dickman. Okay, in this case, the judge had actually revived the privity of contract, where according to the judge, the auditor will only be liable to plaintiff when there is a contractual agreement or whether there is a close proximity relationship between them. And this is what we say the proximity test. Okay, now let's look at the Caparo case. Caparo case is a situation where um, he was the investor and had actually acquired shares in Fidelity in a few stages. Okay, after the last acquisition, Caparo discovered that Fidelity had actually lost of 400,000, and Caparo alleged that Dickman, as the auditor to the Fidelity, had been negligent in preparing the audited accounts. And in this situation, Caparo had actually taken the case to the court, and the issue that have been discussed in this case was actually mainly the issue of the duty of care. The Caparo case actually gives comfort to the auditing profession, where the case had actually decided that the auditor has no duty of care to the investor in making decision relying on the audited financial statements. The case also confirmed that the auditor did not owe duty of care to unidentified potential shareholders or individual shareholder unless the auditor know the person who is going to use the audited financial statement, and also the intention is made clear to the auditor. Lastly, the Caparo case confirmed the privity rule as decided in the Chandler case and the Ultramarines case. In making decision in Caparo's case, the judge had actually developed three tests to establish duty of care of auditor towards the plaintiff. The first one is to test whether the loss and the damages were foreseeable. Okay, here the court will accept that the auditor would have duty of care if, let's say, the auditor would have foreseen that there would be loss and damages suffered by the plaintiff. Okay, the second task is relating to the relationship of proximity between auditor and the plaintiff. Right. In this situation, the court take that it would be unreasonable to establish a relationship of proximity between the auditor and the third party who was not intended recipient of the audit report. Okay, the last test is to determine whether it would be fair, just, reasonable to impose the duty of care on one party for the benefit of another party. So in this situation, the court found that the auditor does not owe duty of care to potential investor or to individual shareholder, but the duty is owed to the corporation shareholders. Um, However, the judges post-Caparo case were not consistent in their verdicts. The last case that I'm going to discuss is the Royal Bank of Scotland versus Bannerman, Johnston, Macleay, and others. Okay, in this case, the plaintiff, that is the Royal Bank of Scotland, had claimed that they relied on the misleading audited accounts when dispersing loan to its customer APC, a company that finally had to go into receivership. And as a result of that, the Royal Bank of Scotland had sued the auditor Bannerman Johnston. The judge that sat in the Scottish court had actually favoured the plaintiff based on the ground that the auditor had duty of care, even though that there was no agreement between the two of them, but the auditor would have known that the Royal Bank of Scotland would use the audited financial statement as well as the audit report prepared by the auditor before making decision to provide loan to APC. And also the judge argued that they favor the plaintiff because even though that the financial statements and the audited financial statements were prepared to the shareholders of the company. Nevertheless, the judge argued that perhaps if Bannerman, the auditor, had inserted a disclaimer statement in the audit report to disclaim about the facts given in the audited financial statement, this can be used as an argument to claim that they have no responsibility towards the Royal Bank of Scotland. And this case had actually impacted the audit profession in Malaysia. What is interesting in this case is that the audit profession in Malaysia had actually implemented the disclaimer statement by modifying the audit report, and this is actually the example of the disclaimer statement. And also the disclaimer statement serve as a statement that the auditor has actually acknowledged that they are only responsible to the shareholders of the company as a body but not individually, and also that they are not responsible to other than the shareholders of the company. To sum up, about the cases that I have mentioned earlier. Questions have been raised as to the role of the auditor and the value of the audit service. Also, the profession has considered to improve on the audit performance by introducing new standard or develop new standard from time to time. And also, the profession has encouraged that the auditor to have a clearer engagement letter. The profession has actually also introduced the concept of the contributory negligence, and also there's issue about the rise in the litigation costs, where the auditor has to consider this seriously. That's all. Thank you for listening.